This is not a topic that's not unfamiliar to the committee. It's eminent domain. And this is a substantial rewrite of eminent domain in Virginia. And I would just read this little piece on it. It revises the prohibition on the enactment by the General Assembly of laws whereby private property may be taken or damaged. An existing provision authorizing the General Assembly to define what constitutes public use is removed. The proposed amendment states that no private property shall be damaged or taken except for public use without just compensation to its owner for the property taken and for damages to the residue caused by the taking or damaging, and that no more private property may be taken than that which is necessary to achieve the stated public use. Just compensation is no less than the value of the property taken and the damage to the residue caused by the taking. A public service company, public service corporation, or railroad exercises the power of eminent domain for public use. Yes, this is a substitute. When such exercise, okay, is for, well, I'm sorry. Just compensation shall be no less than the value of the property taken, business goodwill and access loss, damages to the residue caused by the taking, and damages to adjacent property caused by the taking. That was a change we made. A public service company, public service corporation, or railroad exercises the power of eminent domain for public use from such exercises for the authorized provision of utility, common carrier, or railroad services. In all cases, a taking or damaging of private property is not for public use if the primary use is for private gain, private benefit, private enterprise, increasing jobs, increasing tax revenue, or economic development, except for the elimination of a public nuisance existing on the property. And the last sentence of this language is probably not new law, but the condemnor bears the burden of proving that the use is public without a presumption that it is. There was substantial discussion of this amendment this morning. The recommendation of the subcommittee by a vote of 4-3 was to report, and I so moved.
It's been moved and seconded that the substitute be reported. Delegate Joannou, would you like to speak to the matter?
Yes, ma'am. Madam Senator, ladies and gentlemen of the Senate. First of all, I'd like to say that what this amendment does is that it defines public use. We already have in the Constitution the right of eminent domain. And then we defined it now by statute. And as time goes on, the statute becomes eroded to where a lot of us don't particularly like it. And that's because the people are concerned. This bill basically is a bill of people's rights. And I'm not here opposing utilities or railroads or road builders or anything else. I'm here for the people of Virginia on this particular amendment. Let me tell you one of the reasons we spent a lot of hours on this bill, and we're down to a portion of the bill. And just for briefness, I'll tell you where some of the opposition lies. And if you look at line 32, in the part that, if you start on line 31, just compensation shall be no less than the value of the property taken. It's all right. Inserted was business goodwill and access loss. Okay? And damages to the residue caused by the taking, and damages to the adjacent property taken by caused by the taking. The new language there are two parts to it. One is not that, if I can say, that much opposed, and that part is damages to the adjacent property caused by the taking. Let's say that you have a piece of property, you own a piece of property next to a parcel that has been taken by eminent domain for whatever reason. And half that parcel was taken by eminent domain, the first piece. The second piece, because of the taking, you got some building going on, and it breaks the windows out of the adjoining piece of property, but you don't take any of that property. There's no taking, okay? And that was the reason that we added damages to the adjacent property caused by the taking. And it's pretty specific legally. It has to be a cause of the taking. So one of the things I would like to say is that this is already in the statute. And what we're doing is redefining public uses, okay? Secondly, on line 32, we've included business goodwill and access loss. For example, if you build a 4-lane highway out in a rural area or in a city area you're going through, and on the side of the road there's a gas station, and you close that gas station, they got no access. Today they have no right whatsoever by losing that access. And what does that mean? You close your gas station and leave? None of your property was taken, so you just lose it. That's not fair. It's not fair when you're talking about, and I hate to mention a locality, but down my way, in Tidewater, for example, there were some homes that were taken by redevelopment housing. And they were taken, there was nothing wrong with them. But because one block away from that house, there was a house that was deteriorated and the people moved out and left it. And so what did they do? They took 8 blocks, okay? And they turned around and sold it for a higher price than what they gave to the people who lived there, just for the land. That's not right. A man and a woman work all their life to get a home. And what happens? You go in there and you take that home and sell it to a private developer? For what purpose? You know, it's not right. So all I'm saying to you is those 2 points are the real points of contention in the bill. The business goodwill and access loss, and then some of the road builders are objecting also to the damages adjacent to the property caused by the taking. And it's limited to caused by the taking. It's limited. And those of you who are attorneys understand that point. Now, some people say, well, it's a tougher bill than what you had here on the Senate side. It might be a little tougher, yes. But we're doing this for the people. And why should we have this in the Constitution? Why should we define public use? There's no argument on those lines 36 and down. They're okay. The argument that we have are those that I've just outlined to you, basically. So all I'm saying is, why shouldn't we have it in the Constitution where a person is guaranteed his rights? For the first time ever, we have had utility companies in the Constitution having the right of eminent domain. Go back years and years, and you'll not find that. This is the first time ever. And I understand that they have a few problems with the bill as it stands now. But the bill is for that private individual citizen. And that's the basic reason for this bill. That's the basic reason for saying that we're going to put in the Constitution the definition of public use. And that's basically what we've got. And I think this cures most of the problems. I know that you're going to have a lot of people from industry and all talking against it. And I'd like to have the final word on it, if I may, Madam Chairman.
Thank you, Delegate. Are there questions from the members of the committee for Delegate Joannou?
Madam Chair, I just say we had a full hearing this morning.
Yeah.
I didn't bring my notes, but we had 9 people speak against it from all sorts of groups.
We're going to be very quick in what we do this afternoon. Delegate Joannou, I think Senator Peterson has a question.
Real quick, Johnny, and I appreciate your expertise here, but let me ask you a question. Right now, if somebody condemns property in Virginia, and I represent the landowner, and I put on an expert witness, can't I get into evidence all of the the annual income that the property generates and all of those extrinsic factors as part of his opinion as to the value, which today would go towards, quote, damage of the property. I mean, can I get that into evidence right now through an expert?
The Supreme Court has ruled, it's my understanding, if I can bring the Attorney General. Supreme Court has already ruled that business goodwill and access loss is not damages. I don't understand that, all right? Because I always thought damages meant whatever damage you've incurred, you got, but that's not how the court has interpreted it. And I'd like to bring the Attorney General up.
Follow-up question, Attorney General. So I guess my question is, if I put on an expert witness in a case right now under the existing law, and he gives a valuation of the property, can't his valuation factor in extrinsic factors such as the income yield from the property every year?
If it's a
Excuse me,
taking,
but first you need to identify yourself.
yes, thank you. I'm Steve McCall with the Attorney General's office. If there's a taking of the property and they're trying to value that property, the possible uses for that property would go into the valuation. What is excluded is when someone is moved from that and they say, well, I had relocation expenses, I had lost goodwill, I had lost profits. Those would not factor. So the businesses are left short-handed under existing decisions.
Senator Peterson. All right, Delegate Joannou, you can have a few people speak in favor of this if you wish. A couple people.
John Fraser from Walden and Lyle in support of this bill. As John mentioned, this is a bill for the people. Presently, just compensation, but more importantly, public use has been defined very broadly by our courts. As Johnny said, this is a bill that would define public use. We all remember that Kelo decision that the Supreme Court said the property can be taken for economic development, handed over to a developer, they can do whatever they want. This definition that Johnny's putting forward would stop that in the Commonwealth of Virginia once and for all. It would disallow property to be taken from folks who are otherwise living there or putting it to productive use, just to be handed over to a preferred end user.
Thank you.
Very quickly, Madam Chair, Katie Fraser with the Virginia Agribusiness Council. Just wanted to echo our support of this measure. Thank you.
Let me just stop briefly and turn the meeting back to Senator Howell. And Senator Howell, we've heard from the delegate, and he's having people speak in favor. Thank you.
Sure. Madam Chair, members of the committee, Trey Davis representing the Virginia Farm Bureau Federation. Again, want to echo our support of this measure.
Good afternoon, Madam Chair, members of the committee. Stephen Clark with Walden and Lyle in Norfolk. Want to echo the statements that have been said in support of this amendment. I do believe that the language that Delegate Joannou has identified as being particularly contentious they're important to this amendment. They're important to the people of the Commonwealth. And just to touch on one issue, the issue of loss of access. Currently, the Condon North repeatedly file motions in eminent domain cases to prevent the jury from even hearing expert testimony on the devaluation of property as a result of the loss of access. And so this bill really, or the amendment is designed to put that issue before a jury, to allow a jury to consider that as an issue that could be compensation that would be owed to property owners as a result of the taking and damaging to the property. So I urge you all to vote in favor of this.
Thank you.
Madam Chair, members of the committee, Christy Homick with National Federation of Independent Business, and I also just wanted to echo our support for this bill.
Thank you. Could be brief, we'd appreciate it. And this now is the opposition.
Certainly will be brief. I'm Sandy Cherry with the law firm of Randolph, Ford, Cherry & Vaughn. I'm condemnation working in Virginia for 40 years. I represent a coalition of major public service companies, railroads, utilities. We work very closely with Delegate Joannou, and we appreciate it. We work closely with the Attorney General's office. We were working on this before the session started. We hope at this point to be in a position that we could agree, at least not to oppose the bill. Unfortunately, this morning things changed dramatically, and matters that have nothing whatsoever to do with Kelo reform
were thrown back into the bill this morning, and Delegate Joannou has mentioned those provisions on lines 31 through 33. Let me answer Senator Peterson's question about lost profits. Lost profits are currently admissible in eminent domain if they relate to the intrinsic value of the real estate. And those are put on all the time to show the value of the real estate. After all, it's the real estate, not the business that is being acquired. Let me correct the record with regard to access. The current law is that if the condemnor deprives the land of all reasonable access, that is fully compensable. We end up paying 100% of the value of the land, or at least 90% of the value of the land, if we landlock it. What these folks want is for the landowner to be given a property right in the type of access, the type of entrance that he enjoyed when he bought the property. So if McDonald's had a median cut in front of their property with left in and left out rights, at the time they bought the property, the highway department closes the median, that creates just compensation under this bill. And that's what they want. They want to change the law of access, but it is not a situation where it's not compensable under present law. As far as business goodwill is concerned, before you do anything, check what has happened in California and Florida on business goodwill. It is a crapshoot. It is completely speculative. It is more speculative than damaging the residue of the land. Accountants are needed instead of real estate appraisers in order to value goodwill. Let me make a quick point on adjacent property. This language was just thrown in this morning. I saw it for the first time this morning. When I read the language adjacent property, didn't have too much concern because in my mind adjacent means contiguous. Well, I went to the Karen Harwood actually was the one who told me about it. She told me to go look at the case law. The case law of what adjacent means is that it doesn't mean contiguous. Under Virginia law, adjacent just means nearby. What this does is create a right of action, an inverse condemnation, for somebody 500 yards away from the land that's being taken, none of whose land is being taken, who thinks he's been impacted by whatever public project is being built. It's wide open. It creates compensation where there is none. It has nothing to do with people. I'm glad to answer any questions.
Thank you very much.
Good afternoon, Madam Chairman and members of the committee. My name is Karen Harwood, representing Fairfax County in opposition to this proposal.
Madam Chair, members of the committee, my name is Quick Clement, speaking on behalf of Virginia Utilities Heavy Contractors Council. Just 3 points. We don't object the efforts of Delegate Joannou to define public use. We're concerned about what has been alluded to on the damages and the extent of damages and how speculative it would be to evaluate it and the impact it would have on building roads, the delays that would result. Final point, Delegate Armstrong has had similar legislation in the last 2 years. He doesn't say just access, he also says change or restrictions to access. I don't believe there's a fiscal impact to this bill, but his two bills, one that was filed last year had an estimated $50 million impact over six years, and the one this year had an impact that would increase the cost of just right-of-way acquisition by 60%. And so we're concerned that this would have a very chilling effect, speculatively, not against property owners getting a fair shake, getting duly compensated with the impact it would have on the ability to proceed with road construction. Thank you.
Thank you.
Madam Chairman, I'm Peter Easter, representing the Virginia Transportation Construction Alliance, which is the road builders and the stone quarries. We have concerns on the goodwill, loss of access, and also the adjacent land. We feel that the costs that VDOT would have in building construction projects, as well as the time delay that this would cause.
Madam Chairman, Kathy Fraser with Virginia Natural Gas. I too would like to associate with the comments of Mr. Cherry and Mr. Rust. We worked very hard with the delegate to try and fix the kilo problem, and when it went beyond that to damages, we would just ask that you not see that to not being able to control it in the future by statute.
Madam Chair, David Clark on behalf of Columbia Gas of Virginia, and we associate our comments also with the other utilities who've expressed their opposition to this resolution in its current form.
Thank you.
Madam Chairman, members of the committee, Phil Abraham, representing Virginia Association for Commercial Real Estate. We share the concerns that have been expressed previously. We're particularly concerned about the impact of putting into the Constitution these provisions that haven't yet been tested in the courts, particularly the impact that they will have on the ability to build roads and provide utility services, two critical parts to the state's economic development. I've also been asked to indicate that the Home Builders Association of Virginia shares these concerns. Thank you.
Thank you.
Madam Chair, Mary Bagley with Appalachian Power. We'd like to associate our remarks also with the utilities and both of them. Thank you.
Madam Chair, Kelly Harris Braxton, Virginia First Cities, and I just wanted to mention a couple of things. We feel that the citizens are protected by the legislation that is currently on the books, and that we feel that legislating like this for the Constitution on the fly is a problem. You know, we're seeing that a lot of problems have come up with legislation, with words that have been added just today. So we have a lot of problems with that. We also feel that concerns that people have with certain localities would not occur with the legislation as it is today. Thank you.
Madam Chairman, Scott McCary, Washington Gas. We're compelled to oppose the language coming from the subcommittee on the business good road and loss of access. It takes it just so far beyond the 2007 statute, but it works so well. Thank you.
Bob Mathias, Virginia Beach. We're opposed. Right now, road construction costs or right-of-way construction costs in an urban area are about 30 to 50% just for the right-of-way. We think this could very much increase those right-of-way costs to the detriment of the ability to provide transportation.
Is that?
I think is that
Thank you all for testifying.
I just want to say a few words in closing. I know you all have heard this a dozen times. But when we start talking about lost money, who's losing the money here? The citizens back home are losing it. They're the ones that are being cut out of all this. You know, it's not fair. Yeah, I don't practice this type of law. So I'm not that well versed in it.
Cassius, you might start now.
Yeah, I might start. No, I'm beyond that stage. But seriously, you know, when we're talking about cost, it's going to cost the highway department X amount of dollars more. Well, that's all right. Just take a couple houses and kick the people out and put them in a nursing home. Get rid of them. Who cares? You know, let's talk about who this bill affects. Not bill, constitutional amendment. What rights are being protected? We can go all the way back to England and talk about the constitutional rights, how they came about. You know, we're talking about private citizens. We're talking about people out there on the street. I'm not here for me. And as I told the committee the other day, in 10 years from now, they're probably not even going to know who Joannou was. He'll be dead and buried. You know, the important thing is that our children and grandchildren have the right to say, no, you can't take my property. You don't have a right to take it, and you got to pay me just compensation if you want to take it. What happens to that 65-year-old, 75-year-old man and woman that have been married for 40 or 50 years, and you take them home and kick them out and they go to a nursing home? Oh, that's all right. No, well, forget, the highway department doesn't want to lose another $20,000 on a home. No, let's not do that. Let's talk about a company in Norfolk, all right? Not too long ago, Central Radio. It's located, has a business in Norfolk. It's a Navy contractor, and it's with it has a contract with the Navy Department, and they're in the business of having a central radio I'm sorry, I'm excited. And I'm reading these notes.
We didn't notice.
Well, let me tell you something. You know, this is not for me. This bill is not for us. It's for the people we represent. That's who it's for. You know, and I don't know how to express that any more than I can. I'm not here against the utility companies. I'm not here against any of those companies. Not at all, not one bit. But the people deserve a break. They deserve this right. It's been in the law for years, and what have we done? We've taken the words public use and shoved them over and put them in a statute and have eroded it. And now the Supreme Court came up and said, well, it's your decision, state. You do what you want to do. That's fine with me. You know, I've got statements here where the NAACP came in, where the Southern Leadership Conference came in. I can bring all those up to you and give all these reports to you. But that's not important. What's important is the person that you represent back home. That's who I'm doing this for. I'm not doing it for the utility company or for the highway department or anybody else. I think I have an obligation. Each and one of us have an obligation to the people we represent. And that's the only reason a bill like this ought to protect the rights of citizens. And that's what we're going to talk about. If you want to talk about each issue they brought up, I could do that too. But I'm not going to sit here and waste your time. The most important thing is the people we represent. Let's give them a right. This bill is not a bill. This resolution has to go through 2 times. And then the people have to vote on it. You know that, and I know it. If it's a bad piece of legislation, if it's a bad constitutional amendment, they're going to kill it at the polls in 2 years. Next year, you got to have another bill just like it come before you again. You take a look at it. You listen to the people what said back home. Let's get this bill through this year. And then get a reading from the people back home how they feel about it. I'm just saying to you, that's who we represent, and that's why I'm here today, and I hope in the bottom of my heart that y'all reach a position where you can send this bill out. Thank you very much.
Thank you, Delegate Joannou. My understanding, I wasn't here, but my understanding is the substitute has been agreed to, and there's a motion on the floor to report. Call the roll on report.
Senator Martin.
Aye to report.
Senator Deeds. Senator Whipple.
No by proxy.
Senator Obenshain.
Report yes.
Senator Puckett.
Report yes.
Senator Edwards.
No.
Senator Blevins. Senator McEachin.
No by proxy.
Senator Peterson.
No.
Senator Smith.
Aye.
Senator Barker.
No by proxy.
Senator Northam.
No.
Senator Vogel.
Aye.
Senator McWaters.
Yes.
Senator Howe.
No.
8 ayes, 7 nays.
The bill is reported 8 ayes, 7 noes.
Thank you all.